Hello, my name is Pat McCullough, and I'm the senior partner of McCullough & Associates, attorneys in St. Paul, Minnesota. And I concentrate a significant portion of my practice in family law regarding high asset and complicated divorces, which are called technically dissolution proceedings, but we still call them divorces. I'd like to talk to you for a few minutes about a very important issue regarding divorces if you are so unfortunate to need the services of a divorce attorney. I'm going to talk to you about spousal maintenance, or what you may have heard called alimony, but that is referred to by the courts as spousal maintenance. And that's a payment from one spouse to the other, money to help the one spouse who doesn't have as much income as the other continue to live at a certain standard of living that both spouses enjoyed during the marriage. Who is entitled to spousal maintenance, and for how long a period? That is controlled by our statutes. Statutes are laws passed by the state of Minnesota and then are interpreted by the courts. So then we talk about the case law of how our appellate courts, particularly the Intermediate Appellate Court and the Supreme Court, has interpreted these statutes as to who is entitled to spousal maintenance, how much, and for how long. Spousal maintenance is not like child support. There's no formula. It's based on the need of the party and the ability of the other party to pay. Now, this is kind of a rule of thumb. This isn't the law, but this is kind of a general idea. If there would be a traditional marriage, and I'm talking about traditional when I grew up, a little older than some, where the wife would stay home and take care of the children and the husband would work outside the home. Now, a traditional marriage nowadays, maybe both husband and wife are working. However, a rule of thumb is if you're married under 10 years, generally the spousal maintenance would not be permanent. It would be for a period of time. Also, if it's 20 years or more, and if the wife has been working only part-time or has substantially stayed in the home raising the children, then there's probably going to be permanent spousal maintenance. And permanent would mean merely until maybe the husband retired or until there was some change in the circumstances between the parties, or age 62, 65, whatever, of the husband, or it could be the other way around. There are women that pay spousal maintenance to men. And between 10 and 20 years, it depends on the facts of the case. Again, these are only rules of thumb. There are many factors that go into it. You need to talk to an experienced family law attorney to get more information. Now, much of the emphasis by the judge would be what has been the standard of living of the parties during their marriage. Are there dinners at hamburger joints, or are there dinners generally at some very well-known restaurant? Are there vacations camping, or are they in Europe? Do they have new cars? Do they drive old cars? Do they have a $1 million home, or do they have rental property? All these factors are looked at, and the court attempts to allow the parties to continue, that is both of them, in the same standard of living they enjoyed during the marriage to the extent that funds are available. So what you need to do, you plan a divorce. You don't just walk into a lawyer's office and say, I want to file for a divorce. You can do that, a lot of people do. But it's like most other successful ventures. You should talk to an experienced attorney, especially one that has a lot of experience in the area of alimony or spousal maintenance, whether you're the one that may pay or the one that is going to receive, and you plan, and you don't file until the plan has been completed. Therefore, I would suggest that you find an attorney that has a lot of experience in this area, because this is going to be one of the largest financial commitments, either by way of receipt of spousal maintenance or payment, that you will ever make during your lifetime. Thank you very much.